This Honorable Court of Criminal Appeals of Tennessee is in session.
Good afternoon and welcome everyone to this, the call of the Tennessee Court of Criminal Appeals docket in Jackson, Tennessee. We are delighted that you were able to attend and be with us this afternoon. I want to thank all the people behind the scenes that make this possible. The judge, Clerk Hivner, Jim Hivner staff, as well as the staff at the AOC. And I know the staff of the attorneys that are present have to do things to make sure that we can present on Zoom, and we appreciate that. We're returning to court hopefully in January. It's a general consensus of my colleagues that we're all anxious to get back in courtrooms, and hopefully we will not have to leave again for any particular reason. It's been a good substitute, but it's just a substitute. Nothing's better than being in a courtroom. With that, each side is given 20 minutes. It's the same rules that apply that if we were in person. Mr. Ridley, if you wish to reserve any rebuttal time, please do so upon the beginning of your argument. And with that, I'd like to introduce the great panel you have today, because the entire state's represented. From Middle Tennessee, Judge Tim Easter. From East Tennessee, Judge Norma Ogle. And from West Tennessee, John Everett Williams. Thank you so much. Mr. Ridley, you may proceed.
State of Tennessee versus Kentrel Signer.
Good afternoon, Your Honors. Todd Ridley on behalf of Mr. Signer. Your Honor, if I could have 3 minutes for rebuttal.
Yes, sir.
Your Honors, this is a fairly straightforward case. We're here on three basic possession convictions: one for marijuana, possession of marijuana, possession of oxycodone, and possession of a firearm. All three of these possession convictions stem from a traffic stop where Mr. Signer was in the front passenger seat with the driver and another passenger in the back seat. The firearm was found underneath the front passenger seat. The marijuana and oxycodone were found in the center console of the vehicle. Now, the problem with all three convictions is that the state established possession by Mr. Signer purely and solely through his presence in the vehicle. As this court and the Tennessee Supreme Court have repeatedly found, presence and proximity to the substance or contraband is not enough to establish possession. At trial, and I believe on appeal too, the state has conceded that they cannot prove and did not prove that Mr. Signer was in actual possession of these items. So instead they went on the theory of constructive possession. So for constructive possession, they have to prove that he had the ability to, that he knew about these items and he had the ability to possess them. And to get there, they have to show more than presence and proximity. But here, that's all they did. So first, we can go through some basic facts that I don't think the state will dispute. Mr. Signer was not the owner of this vehicle. He was not the driver of this vehicle. There were no fingerprints found or even taken on the firearm or the other items. There were no admissions or either from Mr. Signer or from the other occupants of the vehicle that would establish his possession of any of these items. No evidence that he knew about the oxycodone or gun at all. The marijuana, I'll agree, is a closer question, and I'll get to that later, but there is no evidence that he was even remotely aware that there was a gun underneath the seat or that there was oxycodone in the center console. The oxycodone was in fact prescribed to the driver's mother, and the driver's mother testified to that effect at trial. So what we have is, for the oxycodone, for instance, is a prescription bottle belonging to the driver's mother with nothing else tying Mr. Signer to that item. And without anything else, without additional proof, whether it was from testimony from one of the occupants, whether it was from additional investigation from the officer, whether it was from taking fingerprints of the contraband to establish Mr. Signer's relationship to them, none of that was done. Instead, what the state did was they said, we stopped the car, Mr. Signer was in the car, and we found these items. Therefore, we can establish possession. That's not enough. That's exactly what this court has said is not enough. That's because what they're doing is they're saying he was present in the vehicle, therefore he had constructive possession of the items. That's not enough to sustain 3 possession convictions. For that reason, we're asking on sufficiency grounds that this court reverse all 3 convictions. I cited a case, a very recent case from this court, State v. Douglas Fortin, where the court found that an item that was outside or in a different part of a house, for instance, that when there was no evidence that the defendant knew about that other item, wasn't in his possession, even though he was in the house and even though the evidence established that he did have possession of some other items, some other incriminating items that were found in that house. Same is true here. Even if he knew about the marijuana, which I think is a little bit closer because the officer did say he smelled marijuana, no evidence that he knew about the other things. No evidence that he knew about the firearm, no evidence that he knew about the oxycodone. And for those reasons, we think the evidence was insufficient. The state's response, at least in its brief, more or less acknowledges those basic facts, more or less says, yes, that's all the proof we put on. We didn't put on anything else. And so what they've done instead of pointing to proof that would directly tie Mr. Signer to the items, again, whether through testimony, through admissions, or through some physical evidence, instead, they've just taken those basic facts and offered up speculation about what those facts could have meant or what those facts might mean. For instance, the state seems to suggest that because Mr. Signer may have been in some kind of romantic relationship with the driver, he therefore had some kind of knowledge of what was in the center console of the vehicle. That's simply not the case. One, most importantly, the state just didn't put on that kind of proof. If the state wanted to show that Mr. Signer, because of his relationship with the driver, knew about what was in the vehicle, then it needed to put on some proof, probably through testimony from the driver, that he had that kind of access, that, oh, well, we've been in a romantic relationship for X number of years and he drives this car all the time, and therefore he would know what's in the center console. That's not what happened, though. We don't know how long this romantic relationship existed, if it existed at all. We don't know whether that relationship extended to him having knowledge of what was in another person's vehicle. And we certainly don't have any indication that he would have known that the driver's mother had an oxycodone prescription that he would have had access to. We just don't know any of that. And the reason we don't know any of that is because the state failed to put on proof establishing those basic facts. So instead, what we're left with is very basic facts that don't establish possession. He was in the vehicle, items were found in the vehicle. That's not enough. That's not enough to tie them to, and it's certainly not enough to show that he had possession over them. One thing that the state did indicate in its proof was it pointed to, well, the gun was underneath the front passenger seat. Well, the officer said all the occupants had access to it. But what the state never did was show that Mr. Signer knew about it. So he gets into a car that doesn't belong to him, and the state is saying, well, anything in that car is fair game, but once he stepped into that car. But that's just another way of saying that his presence is enough to show possession. And as this court again has repeatedly said, it's not. So
who claimed the money?
I am not sure. The proof on the money was a bit suspect. So there was some money, I believe, found in a backpack in the back of the vehicle. The backpack did not belong to Mr. Signer, or at least there was no proof that it belonged to Mr. Signer. The state's argument regarding the money, and it's again unclear from the record how much money it even was, seems to be that because Mr. Signer's mother arrived on the scene to ask for some money, that he had some knowledge of it or knowledge of that particular cash. But again, the proof actually on the money that was in the back of the car, whether the amount or ownership, was not at all clear. And even if it were, it's not relevant to the oxycodone and firearm. Mr. Signer was acquitted of possession with intent, which would really be the only thing that the money would have been relevant to. Even if the state could show that the money in the back of the car definitively belonged to him, which they can't, but even if they could, it doesn't show that he possessed oxycodone that was in the name of the driver's mother, nor does it show that he knew about or had access to the firearm underneath the seat. It's simply an unrelated fact that's not tied to any of the convictions that now exist. The only thing that it would have been relevant to is the possession with intent charge. But again, he was acquitted of that. And he was possibly acquitted of that because they could not tie the money definitively to him. So again, once all that's taken away, what we're left with are really basic facts that establish that he was in a car, and it establishes possibly at most that he knew about the marijuana simply because of the smell. We can all agree to that. But it doesn't show anything about his relationship to that firearm, and it doesn't show anything about his relationship to that oxycodone. And without more, the state's convictions cannot stand. Now, this might be.
Would you admit that the evidence showed that these items were at least readily accessible to your client?
Well, sure. They were readily accessible to him if he knew about them. But otherwise, that is not what the standard is. Readily accessible does not equal possession. Then that would be another way of saying, like, I can be present and have proximity to an item, and they can be accessible to me, but that by itself doesn't show that I possess it. Now, it would be a different thing entirely, and it frequently is from this court's cases. If you were the only driver, or if you were the driver of the vehicle and there were no other occupants and this is all they had, that's probably enough. Just because of the circumstances of, you can assume that somebody who's driving a car, especially somebody who owns it, is going to know generally what's in the car. But as a passenger with an unclear relationship to the driver, that's simply not true for him. So that it's readily accessible does not equate with possession.
I don't recall from the briefs whether or not your client testified. He did not testify.
He did not testify. The mother of the driver testified. I think that was the only defense proof.
Well, how can't the jury infer then, if he doesn't testify, that he knew they were there? I mean, how else are they to make that determination? They can't get inside of his head to find out what if he knew or didn't know they were there.
Well, I guess I would start with, it's a really dangerous thing for the jury to be inferring anything from the fact that he did not testify. That by itself
is that how does a fact finder make a determination on intent then, if the person who intention you're questioning doesn't testify, doesn't say anything? How else are they to make that determination?
Well, generally speaking, you would do it through other proof. In the instance of one of those cases I cited from a federal court, I believe, was about a firearm that was found in a court, and the court said, well, you could check it for fingerprints. You could see who the owner of the firearm is and see if you could tie it to him that way. In a case where you have two other occupants of the vehicle, you could elicit testimony from either of those occupants about who those narcotics and firearm belong to, but they didn't do that. And what Your Honor is suggesting is, well, the jury could just infer from the fact that he didn't testify that he must have possessed it. Well, that would violate his right not to testify. He doesn't have to say anything. What the state is required to do is establish what he knew through other proof. Generally, we do that through other witnesses. If we wanted to show that somebody had possession of something, you would say, find a witness who saw the defendant in possession of it. That is not that hard to do, and it's something we frequently ask the state to do. So if we see somebody, we find marijuana next to somebody, but we don't know where it came from, but you call another witness who says, well, that defendant dropped the marijuana there, then we know he had possession of it. That's what the state's required to do. What the state's asking this court to do, and what they asked the jury to do, is we're going to skip all those steps. We're going to skip our burden. and just say, well, he was there. If he can't testify and explain why it's not his, you should infer that it was. Well, that goes against everything we know about how the burdens of proof work in criminal cases. So the state's failure to conduct an adequate investigation is not an excuse for it to put on no proof and just hope that the jury convicts absent everything else. So what this court can do is say, hey, it's quite possible you could have shown that he was in possession of this, but you didn't. You didn't put on the proof that you were required to put on. You could have called the driver. You could have called the back passenger. You could have called somebody who could tie him to those items. You could have tested that gun for fingerprints. You could have tested the oxycodone bottle for fingerprints. You could have, if you thought he was selling these things, you could have gone to whoever he was selling them to, allegedly, and asked them, did you ever see Mr. Steiner with any of these things? They didn't do that. And that failure is absolutely fatal to the case. And it's certainly fatal to the case if there was some expectation that Mr. Steiner was required to testify as to why he didn't own the things when the state didn't prove it. And so for those reasons, we'd ask the court to reverse his 3 possession convictions. And because it's on sufficiency grounds, that would be the end of the case, and it would just be a reversal with orders to dismiss the indictment. And I'll save, if there are no further questions, I'll save the remainder of my time for rebuttal.
Very good time management, Mr. Ridley. Kentrel?
Good afternoon, and may it please the court. My name is Andrew Coulomb, presenting here on behalf of the state of Tennessee. Let me start off by saying that the state is in no way suggesting that his failure to testify should be, construed to say he knew about the drugs and the gun, and nor I'm fairly sure was Judge Easter implying that silence equals guilt here. I'm pretty sure no one was actually suggesting that, and the state is certainly not taking that position. But when the evidence is viewed in light most favorable to the state, that evidence and that proof sufficiently showed that the defendant was in constructive possession of the drugs and the gun. And I'll start off with the marijuana. There was odor of marijuana was emanating from the car. He was asked about this. He denied it. There was any marijuana there, which we know would be a lie. The driver, his girlfriend, Ms. Atkins, I believe, she indicated that the marijuana was associated with him, or at least the odor of the marijuana was associated with the defendant. So we had that indication. So they search the car and they find a rolled up marijuana cigarette, a blunt, on the front passenger side floor. And now the defendant was the front passenger. So this is on the floorboard, essentially what would have been at his feet. There is a rolled up marijuana cigarette there. So we have, it's not just anywhere in the car. It's not at the driver's side. It's not in the back seat. It's not in the trunk. It's on the floorboard at his feet in this car. So we have the marijuana there, and then we have additional marijuana in the center console, which is essentially the left armrest, his left armrest in the car. So his armrest is there. If you pick that up, there is a bag of leafy marijuana there. So we have the marijuana cigarette, which is right there at his feet, and under his left arm is marijuana in the bag. Between that and the indication by the girlfriend that he had something to do with the marijuana, we have enough to show constructive possession of the marijuana. Then if we turn to the gun was found under the front passenger seat. So again,
if I'm in a car that is owned by somebody else and I am in a front passenger seat and there just happens to be a gun under that seat that I know nothing about, are you saying you can just infer that gun belongs to me?
I think that can be inferred, but we have more than that here. We have more than the fact that there simply happened to be a gun under his seat, the seat he was sitting in. Now, I would note also in the Horton case, which opposing counsel had referenced, the defendant in that case was found lying on a couch. And underneath the couch cushions in that couch was contraband for which he was charged. And this court found in that case that was sufficient to show that he constructively possessed the contraband under the couch on which he was lying when they found him. And here we have defendant sitting on the seat, directly underneath that seat. Again, not the driver's seat, not in the back seat, not in the trunk. Under his seat, we have a loaded gun. We have that, but we have more than that. The defendant's mother showed up very quickly. They were stopped. He was on his phone while they were stopped. She showed up within I think 6 minutes of this stop. His mother showed up, and she sort of gave an explanation about why he would have a gun. She said that he had several people threatened to kill him, and that's why he would have a gun. So we have that too. We have that the mother's is explaining why he would have a gun. We have a gun underneath his seat, right there where he is sitting. And it's not somewhere else. It's not in another part of the car. It's right underneath his seat. And so we have sufficient evidence to show constructive possession of the gun as well. And that would lead us to the oxycodone. So the oxycodone, first, it was right next to the leafy bag of marijuana. So it's not like this is separate. They're right next to one another under the left armrest of the defendant. So we have that, but we also have more than that. In that, so we have the defendant is now found with a loaded gun, with the marijuana, and there is a backpack found in the front passenger area. So this is not in the back of the car. This is in the front passenger area. The backpack was found in the front where the defendant was. And in that backpack, they find a large amount of money. And it's true, we don't know exactly how much it was, but it's on the video. So you can see it's about an inch thick of bills. And it looks like denominations of 20 from what we can tell. But we also see in the videos, it's shown there and it's represented there and it's said there that it was a large amount of money. I think they also used a more indelicate phrase about how much money it was, but it was a large amount of money. And the defendant's mother, when she showed up very quickly, immediately tried to claim it. Said that money is mine, before sort of backing off. The driver of the car, the girlfriend of the defendant, also tried to claim it before backing off. So we know there's a significant amount of money there because multiple parties here are very interested in it, and they're trying to get to it, at least initially. And we can see it from the video. So there's a large amount of cash. This is cash, a large amount of cash on the front passenger side. We have a loaded gun on the front passenger side. We have marijuana on the front passenger side. And then under the left armrest, we have the marijuana, more marijuana, which he's already associated with the marijuana, and we have this pill bottle. Now, yes, it was prescribed to the driver's mother. That's true. However, what we have here is it was filled out 2 days before with 24 pills, I believe it was, and only 10 were in there 2 days later. And there were multiple stories being told to explain why 14 pills went missing in 2 days of oxycodone, excuse me. And it was reasonable for the jury to say, this doesn't make sense. These conflicting stories don't mesh up and they don't make sense. And we have 14 missing pills. So we have the defendant who's got a loaded gun, who's got a lot of cash on his side, right in the front passenger side, not in the driver's side, not in the back seat, not in the trunk, the front passenger side. He's got the gun, he's got the cash, he's got the marijuana, and now we have this bottle of oxycodone with 14 missing pills.
Was this an open console?
It had to be lifted up. So it was a console that you lift up and then you could see what was underneath. Does that make sense?
Yes, that's my question.
Yep. So you'd have to lift it up to see what was underneath there. Lift it up, and there are a few pieces of paper on the front. You lift those up, and that's where you see the marijuana and the oxycodone, or in that center console, which was also the left armrest, like doing double duty there. So, and we have, again, we have the gun tied to the defendant. We have the marijuana tied to the defendant. The gun through the mother helped with that. The girlfriend helped with the marijuana. And now we have the oxycodone pills.
What helps with the oxycodone?
Sorry, could you say it again, Your Honor?
You know, you said this helps tie a defendant to the oxycodone. I mean, to the other things. What helps to tie him to the oxycodone?
Well, this reasonably suggested some sort of selling operation. Now, I know he was acquitted of possession with intent. It looks like the jury cut him a break with that. But if he had been convicted of possession with intent, the same evidence would have been sufficient to show that. We would have been up here doing the same things and was sufficient to show possession with intent. Now, the jury cut him a break for whatever reason, but that doesn't make the evidence any less sufficient to prove the lesser offense, the lesser included offense of possession. And that we have what appears to be some sort of selling. We have a large amount of cash. We have drugs tied to him, and we have the gun. We have all of this, and it's all on his side or under his left arm. And so if you put all that together, it is reasonable to say it looks like he has all of this. He has the marijuana we know. We have the oxycodone right next to the marijuana. He has that too. Now, they did cut him a break and just gave him simple possession, but that doesn't mean the inference is any less reasonable, that he has constructive possession of all of these things. And again, in these cases where this court has said it's not sufficient to show constructive possession, like in Horton, it's where the evidence is removed from the defendant. Like in Horton, the evidence he was sitting on, they found no, he did constructively possess that. The evidence that was in a room with his personal possessions right there, I said that was sufficient. But it was in a different area of the house where there was an HVAC return unit, that he wasn't there and his personal possessions weren't there. They said, oh, well, it's not sufficient to show he constructively possessed that. But that's not what we have here. All of this was, in the front passenger side, under a seat, at his feet, or in the center console, under his left arm. Same thing would be similar in Jones, and that in Jones was a hotel room. The other person in the room, Brandon, opened the door, and right behind him on the table were the drugs and other contraband. So it was not clear at all why the defendant had anything to do with it when Brandon was right there opening the door and right by the table. So those are different type situations. And the other cases that the defendant cites are older cases, and they cite to the pre-Durante's standard. They say, well, it is circumstantial evidence. This is all done by circumstantial, which is true. Constructive possession has to be done by circumstantial evidence. Otherwise, we have actual possession. And those earlier cases that they cited, the defendants cited, I think it was Cooper, Newsom, and White, I think. They all cite the pre-Durante standard and say the state must show that a web of guilt was so tight right here that there was no other reasonable inference you could draw from this. And that, after Durante's, is no longer the standard. The standard is whether a reasonable inference can be drawn from this, not whether the state has to exclude any other one. And so those cases don't hold up under the current analysis. So based on the evidence presented at trial, and this is the evidence, we're talking about what was there. A jury, any rational juror, would reasonably determine that the defendant constructively possessed the drugs and the gun. And for that reason, the judgments of the trial court and the verdicts of the jury should be affirmed. Thank you.
Mr. Ridley?
Okay, I'll be really quick. I guess I'll start with the last point that was made about Durante's and its effect on the relevant standard of review. And my response to that is simply that presence and proximity are the requirement that presence and proximity are not enough goes directly against what the general is saying about Durante's effect on the standard of review. If Durante's had the effect that the general would suggest, then that would no longer be the rule that presence and proximity are not enough, because that's just a circumstance that that a reasonable person might lead to a conclusion of guilt. If you're standing next to the thing, it's reasonable to conclude that you had it at some point, therefore you're guilty. But this court, even post Durante's, has continued to say that presence isn't enough, or proximity is not enough. So I guess that would be response to his general claim that Durante somehow affected that standard. The second one is about his statements about the Horton case. And I guess I would respond, the marijuana in Horton was found in a couch underneath where the defendant was. But when the officers entered the room in Horton, the defendant, who was on top of that marijuana, said to the officers, "I'm just here smoking my dope." And so there was much more than just he was on top of it. He actively admitted that it was his. And I think the rest of the general's argument generally just goes to how much speculation was required because of the absence of proof. The general repeatedly referred to, well, there was a large amount of cash. Well, how much? Well, we don't know because we didn't actually put on that proof at trial. Well, you can kind of sort of maybe see part of it in the video. Well, not really. You can kind of sort of see part of it, maybe, but that doesn't equate to all of a sudden there's a large amount of cash. Why was his mother there? Well, the general reads something very suspicious and nefarious about it. Another way to read it is that a mother was concerned about her 20-year-old son, and it's a small town, and she got there quickly. That's another way to take it. So what that is left with is just repeated acts of speculation on the state to make up for their woefully inadequate investigation and their woefully inadequate efforts to tie Mr. Signer to these items. For another thing, the general makes a fairly big
Make it
deal.
quick, please. Make it quick, please.
Okay, the general makes a fairly big deal about the location of the gun as it relates to the marijuana that was found on the floorboard. Is not clear at all from the record and not clear at all from the proof if one could even see the firearm from where Mr. Signer was sitting. So again, no indication that he knew it was there, certainly not that he had possession of it. And since I'm running out of time, I'll ask the court again to reverse.
Thank you both for very well presented arguments. We'll take it under advisement and we will stand in recess until the call of the next case. Thank you both.
This honorable court is in recess until 2 p.m.